Thank you. Today we're going to explore ADR, or Alternative Dispute Resolution, from my end of it, which is very much community-based, right through to international commercial arbitration. So it's quite a journey we're going to try and get through in the next hour and a quarter. I'm going to just talk for a little while, and then I'm going to show you a video about some of our ADR in action. The law is about right and wrong. It's black and white. Mediations are about navigating and negotiating the grey space of what's fair or fair enough. Mediation is a hard product to sell to the public. We're a litigious lot. We all want our day in court. We set out to prove to the court that we're right and the other party is wrong. Think about a dispute over a fence. I want a paling fence, you want a colorbond fence. I wanted a certain height, you wanted a certain colour. We exchange increasingly hostile letters. Then you threaten to take me to court, and I say, bring it on. The magistrate will clearly see that I'm right and you're wrong. After a lengthy wait and expensive legal advice, our day in court arrives. And guess what? The magistrate does not want to hear my story or your story. She simply makes a decision based on the evidence and the law, right and wrong, black and white. At the end of the story, neither of us is happy. We've spent a lot of money on legal advice, missed days of work, and all over a $2,000 boundary fence. We will be hostile neighbours from here on unless one of us moves. The Dispute Settlement Centre of Victoria, or the DSCV, which is less of a mouthful, deals with neighbourhood, community, interpersonal and civil disputes. All the parties are assessed by dispute assessment officers to determine the suitability of both the parties and the matter for mediation. A significant part of the process is the preparation of parties for mediation. This is to allow parties to debrief and quite often vent their feelings about the dispute. For them to clarify the issues in dispute, there needs to be a substantive matter to negotiate. To determine the willingness to negotiate. If someone will not move from their position, a mediation will fall over before it's even begun. We need to understand the balance of power in the mediation. For example, if we have a represented client and an unrepresented client. Many power imbalances in a mediation can be rectified, for example, with a support person who attends a mediation with a vulnerable party. Assessment ensures that the parties have ability to comprehend the nature of the process and the capacity to make agreements. For example, in the presence of a mental health issue or if a person has compromised cognitive ability. Finally, it's important to reality test the party's expectation of the mediation of the other party and the likely outcome. Preparation is a key aspect of a successful mediation. Without it, parties coming to mediation with a focus on the past rather than the present. The process of mediation is very structured in order to keep a focus on the key issues in dispute, to develop possible options, to consider the alternatives, and to enable parties to work together to reach an agreement that's mutually acceptable. The DSCV uses a co-mediation model, that is, two mediators in the room. Our model allows for each party to have private sessions during the mediation with the mediators. The mediators control how the mediation is conducted, and the parties control what is discussed and what is agreed to. Importantly, at the end of mediation, parties have ownership of their agreement. I want to talk to you about how mediation works in conjunction with the Magistrates Court. The mediation that the Dispute Settlement Centre offers in the Victorian community is fast and simple and is a free alternative to going through the court system. We provide two services to the Magistrates Court. The first is a civil mediation program which was established in 2007. These mediations are conducted for defended matters that are filed under $40,000. They're typically matters around vehicle property damage, insurance claims, incorporated associations, unpaid fines, council rates. The settlement rate of these mediations is 85%, meaning that these matters do not proceed to court through an expensive and time-consuming court case. The program to date has saved more than 800 court sitting days, which in effect allows the court to direct magistrates' resources to other lists. The second service that we provide to the Magistrates' Court is in the area of personal safety intervention order matters. Many of these matters are low-level interpersonal disputes that have escalated over time, and often parties have an ongoing relationships and matters are best resolved by mediation. An example of this is some of the work that we do in the Children's Court. Often it's around two school friends who've had a falling out. This escalates between a Facebook war, postings, war, it's a war, and others becoming involved, and it often branches out to include parents and the school staff. An intervention order may prevent the behaviour between the parties, but it does little to resolve the dispute or repair the relationships. Often orders are impractical. For example, neighbours who live next door to each other who are required to stay 100 metres apart. Imagine collecting the mail. It's complicated. There is no guarantee that when an intervention order ceases that the behaviour will not recommence. Parties can be referred to dispute assessment officers by the court registrars or the magistrates, and they conduct abbreviated mediations often at the court or refer parties on to a more extensive mediation at the centre. Again, 85% of these matters are resolved. The agreements that are reached in these mediations usually contain details about future communication between the parties and quite often result in repaired, if not restored, relationships. Since the commencement of this program, we've saved approximately 2,500 magistrate sitting days, and that's allowing magistrates to hear the family violence intervention order matters. So it's a significant unclogging of the courts. Both the civil and intervention order programs have been evaluated and demonstrate that there are significant savings to parties, courts and governments, not only outcomes that are good for individuals but also for the state. There are many examples of successful mediation processes that reduce the need for protracted court proceedings in interpersonal and medium-scale transactional disputes, such as case conferencing in the Children's Court, the roundtable dispute resolution at Victoria Legal Aid, family dispute resolution in family relationship centres, the Magistrates' Court referral of civil matters to a list of external mediators who work for a capped fee, the use of mediation in lists at VCAT, for example, human rights matters in the workplace. Mediations are also conducted in the higher courts involving large-scale disputes. So I hope that sort of gives you an example of how ADR can work, particularly in a small community, and have an enormous impact on it. Maryborough is a fairly troubled town, and that's a slightly sanitised version because those boys were being very targeted. And there were other groups of kids who were doing a lot of damage and, blaming it on the parkour boys. And just as a sub-note, Hayden, who is the parkour leader in that, went on to star in Wolverine. So there you go. And ended up, we had a whole lot of projects with kids, African kids in Footscray around parkour, and it had the most enormous number of rippling effects. And those boys really were on their way to court, and in fact it was the local magistrate who referred them to us. So just to finish up, there's a growing recognition of mediation. For example, we work very closely with Victoria Police to try and get low-level disputes directly referred to us rather than the courts. And in the last year, our referrals have quadrupled. A key feature of mediation, as it's described there, is that mediators do not provide advice or determine an agreement. Their role is to facilitate the process that allows parties to reach agreement in good faith. These agreements are not generally legally binding or enforceable unless parties choose to make them so. And this is where mediation begins to separate out from conciliation and arbitration, along that continuum that I talked about of alternative dispute resolution. If you want to look at our website, there's lots more information about the sort of mediation that I'm talking about, and that's how you can find us. And that's me done. Thank you.